We're so lucky to have Maureen Martowska as a retired corporate attorney living in Lakeville, Massachusetts. She's previously involved in general law practice, Social Security disability, law and bankruptcy filings. She's a current member of the Massachusetts Bar Association, a former licensed secondary education teacher, and she's had a 15-year career as a technical writer employed by Fortune 500 companies such as Raytheon on very highly classified defense contracts, a former certified mediator. She's a former counselor certified by the Massachusetts Executive Office of Elder Affairs in Massachusetts, advocating for the elderly and disabled, and an active and involved grandparent. That's so nice. Working with several Connecticut legislatures. She has helped to draft and amend several statutes and legislation relative to guardian ad litem reform, shared parenting initiatives, and psychological evaluation reform in Connecticut. She's also a current member of the National Alliance on Mental Health, also known as NAMI. However, the experiences that have most impacted and prepared Maureen as an advocate for parents seeking access to their children is her own very personal journey with the Connecticut court's denial of her son's access to his children based on the failure of the court to adequately provide relevant and ongoing training and education to their own administrative staff, as well as the legal and behavioral health providers involved with the courts relative to mental health, in particular parental alienation. A situation her family is all unfortunately too familiar with, dating back to 2005, and is still ongoing to this day. So please welcome Maureen, who's going to speak with us tonight about the kind of legal speak that goes on surrounding divorce. It can be overwhelming, and there's a lot of terminology out there. So Maureen, I'm going to hand that off to you, and then we'll take some questions after you're finished.
Great. Thank you, Colleen, and thank you everybody for taking the time to listen tonight. I'm happy to be here. As a retired attorney, I do have to advise that I'm not able to give legal advice, and none of this should be construed as legal advice. And but I highly recommend that if you do have legal questions, that you find a competent licensed attorney within the jurisdiction, and that's how you should proceed. But I will share my personal experiences and personal knowledge and opinions with you. So I'll begin with shared parenting in the state of Connecticut. Several states have adopted a presumption of joint custody that have included states like Florida, Idaho, Louisiana, Minnesota, New Hampshire, New Mexico, Texas, Utah, Wisconsin, and the District of Columbia. In these states, when parents cannot agree, the judge grants joint custody for both parents. Connecticut is one of the states, though, whereas joint custody requires that there's an agreement of both parents. There are other states that are like us, unlike those states that I just mentioned to you, where in those states, when the parents can't agree, the judge grants joint custody, joint custody for them. In Connecticut, it is given only when it is the agreement of both parents. And there are other states that are like Connecticut: Alabama, California, Mississippi, and Nevada. What a lot of people misunderstand is they mix up what is custody. And there should be a distinction. There are two types of custody. There's physical custody, and there is legal decision-making. With the physical custody, that refers to a child's living situation. If you're given sole physical custody, your child will physically be living with you, and you are what's called the custodial parent versus the non-custodial parent. A custodial parent means that that parent will be providing the child's primary residence. Non-custodial parents cannot be denied or have his or her parenting time reduced simply because he or she is in arrears in child support. That is a misunderstanding by a lot of people. There's no connection to the two. So if you are a non-custodial parent, you should be headed to court if you were denied parenting time simply because you're in arrears on your child support. Shared custody means that the child will have time visiting with you, but shared custody does not necessarily mean equal time. Under the Connecticut Child Support Guidelines, shared custody is when the child has what they call, quote, substantially equal time, unquote, in contact with each parent. Deviation can be warranted for shared parenting, for the shared physical custody, where the parents have substantially equal income. When we talked about the second type of custody, I was talking about legal decision-making. That's the ability to make major decisions for your children in terms of their education, their health care, and their religion. So when somebody gets joint custody, we're talking about joint legal decision-making. That's what we're talking about typically. And there's a specific statute in Connecticut that is in the family court is used all the time. It's section 46B-56A. It's a joint custody statute. It's an important statute because that is the statute that defines joint custody as joint decision-making and physical custody being shared by the parents to assure the child of continuing contact with both parents. The court may award legal custody without awarding joint physical custody. And that's an important thing for people to understand. You can have joint legal decision-making even though you may not have joint physical custody. There is a presumption of shared custody. If you look under section 46B-56A, again, that's the joint custody statute, a very important statute to parents. There is a presumption affecting the burden of proof that joint custody is in the best interests of the child. And that is stated in section B of that statute. That statute goes on to tell us that if the court declines to enter an order awarding joint custody pursuant to that subsection, the court shall state in its decision the reasons for denying an award of joint custody. So parents where there is not an award of joint custody should make sure in any order that emanates from the court that that is articulated in the court order, the basic facts as to why joint custody was not issued. And it's a very important point, and I'll tell you why. If the parents want to go and appeal any type of decision from the court, there has to be findings articulated as to the basis of why joint custody was not given. So that's very, very important because an appellate court can deny to hear it if it cannot get an articulation on the basis for not giving the joint custody, because it's up to the parent to perfect what they call perfect the record on any appeal. So it's very important, that point that I just made out. Another point in this statute is parents are required to file, when they initially file, whether they're when they're going in for custody, for a proposed parental responsibility plan. They can propose that themselves, submit it into the court, or have their attorney do that. A proposed parental responsibility plan will lay out who has the decision-making authority, how future disputes are going to be resolved. They will give provisions for dealing with the parent's failure to honor their responsibility, what they do with the child over the years, how the child's changing needs need to be addressed. They will also, a responsibility plan will also minimize the child's exposure to harmful parental conflict, and it will provide for the child's physical care and emotional stability. And if both parents consent to a parental responsibility plan under this section, it shall be approved by the court. In other words, the court needs to approve a plan if both parents can come to a mutual agreement, unless the court finds that such plan that was submitted is not in the best interest of the child. As most of us know, that is the primary consideration and the discretion given to the court. What is in the best interest of the child? So though the parents have the right to submit that and have it agreed to and blessed by the court under a court order, as far as the responsibility plan, and issue an order from that, it doesn't mean that the judge will do it if he or she doesn't feel that it's in the best interest of the child. Presumption regarding the best interest of the child. There is a presumption under, this is section 46B-56B. The title of the statute is Presumption Regarding Best Interest of the Child. It is the best interest to be in the custody of the parent. That is stated clearly in that statute. And it can be rebutted, though, by showing that it would be detrimental to the child. So even though there is a presumption that it is, it can be rebutted. There is one doctrine that is very well known to lawyers. It's called the Parens Patriae doctrine. It's a doctrine that every state in this nation has. And what it does is, and this is where the parent typically will declare, I have the right to decide what is going to happen with my children. The state, though, will take a look and say, look, you availed yourself to the courts. We have the right to decide what's in the best interest of the child because you did so. And you can see that play out in things like termination of parental rights, but also with family, just the typical family cases that come in, because the courts feel that since you availed yourself coming into the court, they have this Parens Patriae doctrine. It is Latin for parent of the nation. It is a public policy power given that each state assumes and takes authority in to intervene against abusive and negligent parent, but also it can intervene if parent or the child is in need of protection. So that is where a lot of people will stand on their constitutional issues. And I'm not saying that that's wrong. I totally, myself personally, agree with the Constitution, due process, the idea of liberty interest that the parent has in the care, custody, and control of their children. However, the state will stand up for a Parens Patriae in their duty to protect the child. And again, that's a supreme power that the state claims. The family court, just recently, there was an appellate case called Kosciuszko versus Parham in 2019. That case is Kosciuszko, where the family court felt that they could not enforce custody issues decided by arbitration. In other words, some people, when they come into the family court, seek out arbitration, not to be confused with mediation. Arbitration is a legal and binding decision that a neutral person will take after hearing both parents' side. That's not what mediation is. This arbitration, the arbitrator has that power to do that. But the court said that any decision or order or ruling that comes out of that arbitrator is not enforceable in 2019 by this case, because they said it is bedrock state policy that the authority lies with the family courts to make decisions regarding the best interests of the minor children. So that's important to remember as far as arbitration in regards to family court cases. I did want to go over the best interests of the child. They're just referring you to the statute. 46B-56, again, is a very important one because it talks about the best interests of the child. And basically, it's a 16-factor test. It includes some things as deciding the temperament and developmental needs of the child, the capacity of the parents to understand and meet the needs of the child, informed preferences by the child, the wishes of the child's parents, past and present interaction with the child, the willingness and ability of each parent to facilitate and encourage continuing parent-child relationship. And this comes into play, especially when we're talking about parental alienation. This is one of the points, the best interest point, that should definitely be brought up in your evidentiary trials, because if the parent is not doing this, he or she's not acting in the best interest of the child. There's also factor 7, which is manipulation or coercive behavior by the parents in an effort to involve the child in the parent's dispute. That also plays into parental alienation. They also look at factors such as the child's adjustment at his or her home, the length of time the child's lived in a stable environment, the stability of the child in the existing environment that he or she is in, the cultural background, whether there was any domestic violence and any abuse or neglect. And they also look, has there been participation in parental education? This statute also allows, and this is very important, it allows for access to the child's records, even if a parent was not granted custody of a minor child. Even parents who are not granted custody of a minor child, they shall not be denied, that's the wording, the right to access the academic, medical, hospital, and other healthcare records. This has become a problem with some parents, and even with parents who are granted custody. If one parent says, hey, they don't have joint physical custody. A lot of educational institutions are unfamiliar with that, so you will need to show this statute to them. One of the other things I wanted to cover was constitutional rights. Parents have a Constitution fundamental right to make decisions regarding the care, custody, and control of their children. This was laid out in the 2000 U.S. Supreme Court case called Troxel v. Granville. It was a case that really was about grandparents' rights. When grandparents sought to visit with their grandchild, when their son died, the couple wasn't married, they had 2 children, but when the son was alive, every weekend the children were coming over. The lower courts had said that, yes, the grandparents should have visitation. When it went up eventually to the appellate court, up to the Supreme Court had said, look, parents have paramount authority. This is really important, a real important concept. Again, they have the constitutional right and the paramount authority to the care, custody, and control of their children, even when it comes to grandparents, because parents are thought to always look out for the best interests of their children. That is a default sort of position that the courts have given to parents, and that's a point that should always be argued, the paramount authority. The constitutional right under the 14th Amendment of liberty interests of the parent to look out for their children, but also to their own individual right as parents to the care, custody, and control of their children. So that is one of the major things I wanted to bring out. And I know I'm running up against the time, but one of the other main things that came out of this case was the special weight that the courts are required to give, and they call it special weight to parents' decisions. This is very important, and it's very useful to parents when they go into court to argue their rights. So I did want to point out one other thing, but there are other things I would talk about, but I do want to talk about family courts and a helpful thing to parents. When you step foot into that courtroom, when parents aren't agreeing, there are free access to mediation through family services, free issued focused exams, free comprehensive evaluations. These are things that if you don't come from money and you're looking to expedite the process, because a long entailed process not only emotionally drains the parents, but financially does. These are great resources to more expeditiously get to the end line, the end point of trying to get access to your children and get a plan out there. So I just wanted to raise that to you. They have free issued focused exams, free comprehensive evaluations. And the important thing is you have to make a motion to the court to have family services offer these and then have the court issue an order. Important, when the court issues an order, ask that the court issues an order, or rather when you agree to this, having one of these exams, the parties do. Let's say they come to a mutual agreement and sign a stipulated agreement. In that agreement, please put in that it is agreed that this court, that these evaluations will be provided to the court for their review and recommendations for a court order. It'll save a lot of time. So I'll leave it there. There's more I could say, but if there's questions, I'm more than happy to answer.
Thank you, Maureen. That was phenomenal. There's so much information, right? I mean, you gave us so much information to think about. One of the things that you brought up that I wanted to talk about was, you were talking about, you know, the court process and bringing families into the court process. Just from your recommendation, your experience, would you say that trying to mediate cases prior to and trying to come to the, you know, a family's own agreement, the husband and the wife, or whatever the dynamic of the family is, the makeup, would you say that that is probably a better place to start to agree on as much as you can possibly agree on?
After 15 years in the system, the court system, and being, you know, having the experience as a grandparent, observing my son's own experience, and being educated as a lawyer, I will tell you that courts are set up as adversarial systems. So whenever you can get into mediation, to be in a situation where you're conciliatory, where you're trying to work together, where finances aren't an incentive to outside vendors such as, you know, therapists, evaluators, a whole host of different people, it can really, really help to try to calm. The sooner you get to it, the better, the less time to escalate tensions, and more likely that you'll have a positive and more timely outcome. Yes, I totally agree with that.
Thank you. Thank you. Well, why don't we open it up to anybody else that might have a question for Maureen?
I guess everybody on this call understands that to raise your hand, you hover over participants and click on participants, and that gives you a chance to raise your hand, which you can see next to your name. This is kind of practice because there are only 5 of us on this call. So would somebody raise their hand, please? Okay, Suresh. Go ahead, Suresh.
Thank you. That was a very useful talk, Maureen. I have a quick question. I know you went through lots of comments on constitutional rights of the parent. What happens when there is an agreement, you know, that is signed by a parent, mainly because, you know, there was a restraining order filed or something like that, and they just wanted to, they get into a signed agreement. But how, you know, is there any way to dismiss that agreement later on and say, well, these are my constitutional rights. You have to show that I am an unfit parent in order to take my children away or take physical custody away from me?
There's a signed agreement, and I don't mean just by, typically parents can come to an agreement and sign what they call a stipulated agreement. It's a very, that in and of itself won't have the force that it could have if you have not brought it to the court to bless it. Because again, as I had introduced in the beginning, parents can decide what's in the best interest of the child and come to a mutual decision, but they really need to come before the court to get it blessed in a court order. And the court basically signs off on the agreement and dates it if they do that. And that is enforceable. And if you find that somebody is not adhering to it, that is where typically a motion for contempt would be submitted into the court. Motions for contempt, by the way, are given priority. They are more quickly heard than short calendar matters for other types of motions. So that would probably be, in my opinion, the best way to address that. But definitely they are, if it's a court order that was issued based on that agreement, yes, it's definitely something that the court should be enforcing.
Maureen, can I just thank you for that? But prior to, you know, when there's a contempt of the order, instead of immediately going back to court to ask the court to intervene and create and help with the decision making, because I'm always going to go back to would it be in a party's best interest to see if they can mediate it out together with a mediator, and or just see if they can have their attorneys work collaboratively to try to work that out, and that seeking contempt order would be kind of the last thing you'd want to have to do.
Yes, absolutely. Again, you're trying to de-escalate the situation. And I think it also lessens the tension between the two parents when the parents can see the other parents willing to sort of work with her. And again, it's again how you can approach your approach to the, to between the attorneys or between self-represented parties or an attorney with a self-represented party is very important on how you approach, because people are people, they have a lot of emotions. And I think it absolutely, I agree, that would be a better initial step to take.
Okay,
Yes.
thank you. Anybody else have any questions for Maureen?
Eric, go ahead.
Hi, Maureen.
Hi, Eric.
I guess I have a question. Can a judge or could a court petitioner ask a judge to order like 3 attempts at mediation? Is there a way for a judge to look for the out, or for a petitioner to ask for the out instead of being in an adversarial place to order a shot at mediation?
Yeah. So a court cannot order a person to mediate unless the other party is willing to do that. But in real life, how people, I've seen it done, people have put in what they call a motion for order to mediate. And the other party will come in, and they do know that they especially if they're represented by counsel, that you can't order mediation. You really can't order that. It has to be with the agreement of the other party to mediate. So what they can do is they can say, there may be some things that the court can do to entice a person into mediation, by telling them how it works for the best interest of the child, trying to get them on board with it. But those are things you can, as tactically, it doesn't mean that you can't try it. And that sometimes it's successful, sometimes it's not, because the mere pressure of the parties being brought before the judge and the judge being aware, hey, we've got an uncooperating party, may be enough to say, are you willing to mediate? And the other party will say, all right, and the judge will typically offer, and there's free mediation if the parties can't afford it through family services, or give them other places where it is accessible. And then what would happen is the judge would say, okay, I'm going to put an order that will allow for the parties to attend, mediation, but that's typically how it goes, Eric.
Very nice. We're a couple of minutes over schedule. We did want to try to keep it to about half an hour. There's so much here, Maureen. It's wonderful what you're doing. I hope we can have other Tuesdays on maybe selected topics, like
Yes.
The alienation topic. I know is a big one with a lot of people, or the constitutional rights topic. I'm interested in sort of the way things work in practice. So I have some thoughts there, but it's no time to discuss those now. But sometimes the practice is a little bit different than what the actual legal documents say.
Yeah.
I found that anyway. So I hope that we can get you back for other Tuesdays. This is wonderful. Really
Sure,
appreciate
no
it.
problem. No problem.
Awesome.
Okay.
Thank you, everybody.
Thank you all. Very
Thank
nice
you.
job. Excellent. Yeah.
Okay.
Bye.
Bye-bye.